So legal issues in phlebotomy. So why are we going to study legal issues? Well, it can happen to you. So has been gradual inflation in the price of all goods and services. So there is a higher cost for the equipment purchase and maintenance of that equipment, and there is a need for highly trained operators at all levels of healthcare delivery. So going back to the higher costs, the cost of drawing a blood sample has risen significantly since the development of safety needles and other systems that are designed to actually protect the phlebotomist or others that are drawing the blood samples. The availability of sophisticated technology has meant that more doctors are actually ordering more tests than before on patients, and that more patients expect them to order the test as well. So with the internet and everything out there, everybody has access to basically everything, right? So a lot of times patients are asking for certain things, or talking to their doctors, and they're actually getting more than they were previously. So as the standard of care has risen, multiple sophisticated and expensive tests have been prescribed to help supplement the physician's clinical judgment. So it could be a test that's not performed very often, or one that is very labor intensive, which in turn leads to a very high cost. There's also a fear of litigation or being sued, has also fueled the rise of the use for multiple tests, because the physicians don't want to be sued for malpractice or anything like that if let's say they missed something. So a lot of times physicians will order, or some physicians I should say, will order a whole battery of tests just to be able to rule stuff out. So that defensive medicine is what they call it, is understandable. It's given the very high cost of malpractice insurance and the potential for a liability judgment that could make their name be not good anymore, just in case if there is the event of an oversight or a mistake. There's also the rising cost of healthcare, which has led to efforts to keep costs under control. There is reimbursement restrictions on certain diagnostic tests and limitations on the prescription drugs. So the rights of patients have been increasingly recognized and expanded. So the level of care expected by patients has grown as well. So the patient care partnership. So what to expect during a hospital stay. As a patient, you are expecting high quality hospital care, a clean and safe environment. You want involvement in your care. You don't want one person just coming in making the decisions. You would rather have a team of professionals looking over your case to make sure there's nothing missing. You want to make sure there's protection of your privacy. You want to make sure that you have help when leaving the hospital, and also have help with your billing claims if needed. So when you need hospital care, your doctor and the nurses and other professionals at the hospital are committed to working with you and your family to meet your healthcare needs. There are certain laws that we're going to talk about. So statutory law is created by a legislative body. This occurs at the federal level. So this is Congress, made up of the Senate and the House of Representatives, that make these types of laws. There's a case law that is determined by court decisions, usually as an interpretation of an existing statutory law. And then administrative law is created by administrative agencies like the IRS or OSHA. So state legislative bodies vary from state to state, but usually follow the federal model. The Supreme Court has ultimate jurisdiction over all laws, whether they are federal or state. The regulations promulgated by these agencies are given the force of law by the statutory laws that created the agency. These laws are classified as either public or private. When a public law is violated, the offense leads to a criminal action, and the violator is prosecuted by the public in the person of the government's attorney. The offense may be either a felony or a misdemeanor, depending on the seriousness of the crime. So a phlebotomist can be charged with violations of public law, a failure to obtain an informed consent from a patient before any procedure could be an example of this. There's also an example of not following HIPAA compliance. So, talking about patient information with people, doesn't pertain to their job or outside of your work. That could also, feed into this as well. If a patient refuses to have his or her blood drawn, the phlebotomist must not attempt to force the patient to comply. Generally, at this point, it's going to depend on your facility what the procedure is, But usually at this point, you're just going to go let the nurse or the physician know that the patient refused. And then from there, you're done. They may call you back to draw after they've had a chance to talk with the patient. But you, as a phlebotomist, are under no, you don't need to talk to the patient to try to talk them into it. That is not your responsibility to do. To persist, if you were to keep trying to persuade them, it could lead to a criminal charge of assault and battery. Assault is an unjustifiable attempt to touch another person or the threat to do so, where battery is the intentional touching of another person without consent. So with that, there are only a few situations where the person whose blood is being drawn is not the person whose consent must be obtained. So parents have the right to give consent for a child to have his or her blood drawn, even if the child is refusing. So that happens a lot, right? Children are scared, especially of needles. They're in a weird place. They have weird people talking to them. So they get nervous. They get scared. They don't want it. They'll scream. They'll cry. If the parent has given consent and the child is under 18, then we can go ahead and do it. There are also legally appointed guardians that can give consent for patients who are incapacitated. So if we have a durable, power of attorney or medical power of attorney, that person can make those decisions for a patient if they cannot make their own decision. So basically, just know if there's any doubt about who is entitled to give consent, always ask the nurse or physician before proceeding with the draw. Now, I will say as a caveat, you will generally not run into this too often, but just make sure you are aware that this is a possibility. So in contrast to public law, when a private law is violated, the offense may lead to a civil action. And that's basically when the defendant is sued in civil court by the plaintiff, and then the person claiming to have been harmed by the defendant. So civil wrongs include torts. A tort is defined as any wrongful act that causes harm or injury to another person. And the torts can be either intentional or unintentional. The unintentional torts are the basis for most medical malpractice suits. A malpractice suit may be brought against the individual causing the harm, the institution employing the individual, or both. Supervisors may be held liable for the harms caused by an individual under their supervision as well. And a patient may choose to bring a civil action in a case for which a criminal action was also brought, whether or not the defendant was found guilty in the criminal action. So for instance, a patient with a damaged nerve, from a phlebotomy, a blood draw, may sue for malpractice even if the case was not strong enough to sustain a criminal action. Other causes of action could include reusing a needle, which you should never do, careless probing for a vein, which means you're sticking it and then you're moving it around a lot, accidental artery stick resulting in injury to the patient, drawing samples that are not requested by the physician, or releasing test results to someone that is not authorized to receive them. A patient must file a civil action within a specified time period after the damage occurred, and that's usually within 2 years. And this time period is called the statute of limitations. Settlement and judgment. In an out-of-court settlement, the two parties will reach an agreement without any intervention of a jury. So basically, they don't go through the whole court process. They make an agreement outside of that. So when the parties cannot reach the agreement, the case then will go to court for trial and judgment. Judgment against the defendant in a civil case usually results in a fine, which may be only compensatory or punitive. So almost all civil and criminal actions are settled out of court. When a civil case is settled out of court, the settlement often includes a condition stating that neither party may discuss the amount of the settlement. Judgments in either civil or criminal actions can be appealed if the losing party feels that some part of the court proceeding was in error, and these judgments may be upheld, reversed, or modified on appeal. Professional liability. So your scope of practice is the set of procedures and responsibilities for which you are training, has prepared you, and for which you have demonstrated competency. So like mentioned earlier, making sure that you are getting that checklist complete because you want to make sure that you have shown your competence in doing this procedure prior to doing it. Okay, so make sure you are up to date on those. So professional liability. Liable means that you are legally responsible for an action and can be held accountable for its consequences. You must perform only those procedures that you have been properly trained to perform and that fall within your scope of practice. So scope of practice, what that means basically is what a phlebotomist is supposed to do, what your job description states you can do. So we, as a phlebotomist, are not going to be giving medications, right? That is outside of our scope of practice. But drawing blood is within our scope of practice. So that's kind of where that falls. A professional should not attempt to perform duties for which he or she is not trained. So again, sometimes you'll run into certain situations, especially I will say if something's going wrong, let's say in the emergency department, they'll be like, hey, can you start an IV? If you have not been trained to do that and been checked off to do that, and if that's not in your scope of practice based on your facility's protocols, then no, you can't. Okay, so make sure you stick to your guns on that. Standard of care. So an example of a standard of care is phlebotomists violate the standard of care if a dirty needle is not properly disposed of and is then used on another patient. Or if the phlebotomist probes during the venipuncture to find the vein and then damages the nerve with improper drawing techniques. So when that standard of care is not followed, those professionals who were responsible for decision making in that situation are going to be held liable for injuries that are incurred by the patient. So judgments regarding medical liability revolve around the concept of the accepted standard of care, which represents the consensus of medical opinion on patient care in a particular situation. Negligence is the failure to perform an action consistent with the accepted standard of care. So an example of that, like we mentioned earlier, would be reusing a dirty needle. That would be negligence. Medical malpractice. So malpractice is the delivery of substandard care that results in the harm or death of the patient. Sometimes this can be called medical professional liability. A malpractice suit usually will name one or more professionals that were involved, as well as the institution of where it occurred, as the defendants. The suit alleges professional negligence as the cause of specific harms, which may include both physical and emotional distress, as well as lost income or potential income as the result of what happened to the patient. In a civil suit, the plaintiff asks for damages or monetary compensation. Damages may be awarded to cover only the actual cost of the injury, such as lost wages or if they needed any additional medical care to fix whatever went wrong. Damages can also be awarded to compensate for legal cost or pain and suffering as well. Punitive damages may be awarded to punish the defendant, usually for gross violations of accepted standards of care. So something they knew was wrong and they still did it anyway, type situations. There are 4 elements of negligence. So we have duty. The plaintiff must prove that the defendant owed a certain level of care. Dereliction revolves around the accepted standard of care and the action or inaction of the plaintiff. Injury, there must be proof that a legally recognizable injury occurred to the patient. And direct cause, there must be proof that the injury was direct result of the defendant's action or inactions. So an example, a phlebotomist does not follow the procedure for identifying the patient and the wrong patient is drawn. So now as a result, the patient receives the wrong unit of blood and dies. There is no way to defend in a court of law a reason for drawing the wrong patient when there are procedures in place to prevent this. So this would be considered pure negligence. Defense against malpractice. So if for some reason something were to happen to you and you would have to defend it, you would need to show that the standard of care was followed. All parties should carefully document exactly what happened. And each institution will have a set of protocols for reporting these incidents. So when and if they do happen, make sure you are reporting them because that is extremely important. This usually involves prompt and complete documentation of the circumstances of the incident in an event report. So documentation is key, really in all aspects of the lab and healthcare, to be honest. So make sure you always maintain clear and complete medical records. And whenever an unusual incident does occur during a phlebotomy procedure, make sure you report it to your supervisor immediately and fill out an event report or follow your facility's protocols depending on what it is. Most facilities will have a procedure to follow, like where you go and you fill out the report, to make sure it's documented and follow up from there. Some more defense against malpractice. So patient communication is also an important aspect of preventing malpractice claims. Make sure you always obtain positive informed consent before you perform a procedure. Procedures must be explained in a way that the patient can understand, and the patient must give positive consent. The only time nonverbal consent is considered acceptable is in cases where immediate action must be taken to save a patient's life. So the only time, as mentioned, that nonverbal consent is acceptable is when we need to save their life, and that is called implied consent. So somebody comes in and they're unresponsive from a car accident, we are going to use implied consent that they want their blood drawn to save their life. Liability insurance. So liability insurance are usually protected by their employer's liability insurance, although some phlebotomists also obtain their own. I will say each place I've worked, we have had our employer's liability insurance cover the phlebotomist. But it does cover monetary damages that must be paid if the defendant loses a liability suit. And most hospitals require a doctor to show proof of insurance before receiving admitting privileges. Confidentiality. So phlebotomists are bound by both legal and ethical responsibilities. Privacy of medical information is of utmost importance. So this is where HIPAA comes into play. So privacy of medical information has taken on legal ramifications as well. So HIPAA, you've heard me say it a few times. What is it? It's the Health Insurance Portability and Accountability Act. HIPAA defines a set of standards and procedures for protection of privacy of health information. Under HIPAA, patients have the right to control their PHI or protected health information, and disclosing PHI without the patient's consent is considered illegal. In addition to legal obligations, the phlebotomist is bound by both legal and ethical responsibilities, especially in the area of confidentiality. With the passage of the HIPAA Act, the privacy of medical information has taken on legal ramifications. The patient or protected health information is considered any part of a patient's health information that is linked to information that identifies the patient, such as date of birth, name, address. It can include diagnosis, what they're in for, what they're having done. Really, you can't say really anything unless it's for your job and you're talking with somebody like a nurse and they needed to know something. So for HIPAA, you are never going to discuss a patient's condition in a public place, such as a hallway, elevator, or eating area. You're never going to discuss information concerning a patient with someone not involved in that patient's care. You are never going to release medical information concerning a patient to anyone not specifically authorized to acquire it. You're never going to leave patient records out where patients or visitors can glance on them. And always log off computers when tasks are complete. So if you don't log off that computer and somebody gets on and starts looking up patient information that they shouldn't be, it's going to be on you. So make sure that you are logging off those computers so nobody else has access to it, because they can track, based on your login, who was in it. So they would know, or they would assume it was you, even though it wasn't. So make sure that you do that every single time you step away.